Hi, everybody. Welcome back. As European societies become more diverse and cultural clashes increase, crime rates tend to rise along with them, especially in the large European cities. And as this happens, inquisitorial systems across Europe are experiencing pressures on judicial resources that are much like those in the adversarial systems and lead judicial officials to seek less costly alternative modes of resolving cases, just as they do in the adversarial systems where plea bargaining is the preferred solution. But in the European systems, as we've seen, plea bargain is apparently not an option at all. And so in this last lecture, I'd like to consider the question of how the inquisitorial systems of Europe have addressed the problem of rising crime rates and limited resources available to the judicial system. One common way that the European systems have approached the problem is to draw a line separating crimes that are more serious from crimes that are less serious, and then to divert the latter, less serious crimes to less formal, less costly procedures. Americans have a similar sort of rule, and the criminal law of the United States defines and describes offenses and divides them into two categories: crimes or felonies, which are most serious, and misdemeanors, which are less serious. And in some respects, the procedures that the American system uses to deal with felonies are different than those for misdemeanors. Different kinds of courts can hear misdemeanor cases than can hear felony cases. That's the idea in Europe as well. It's to draw a line that separates felonies from misdemeanors, as Americans would put it, and then to divert the cases in the lower seriousness category to these less formal, less costly procedures, where at the end of the day, less is at stake for the defendant and less at stake for the society than in the cases of more serious crime. This happens in France, where formal inquisitorial trials with all of the machinery that they require, the investigation and the production of the criminal dossier on which the questioning at the trial is based, etc. All of these things cost money, not as much money as an American criminal trial, but not an inconsiderable sum in any case. In France, formal trials in what are called the courts of assize are reserved for serious crime. I don't speak French, so I hope I have that right. And what Americans would call misdemeanors and the French call délits are resolved in less costly courts called correctional courts. So, indeed, some cases can be resolved cheaply, other cases can be resolved only by engaging the entire mechanism of the inquisitorial trial, and France reserves the inquisitorial trial for the more serious crimes. However, prosecutors routinely transform crime into délit and thus subject defendants to lower sentences if those defendants will agree to forego the more formal procedures. Every offender in France, as in the United States, has the right to a full criminal trial if the offender demands it. But if a prosecutor thinks that the charge that the defendant has actually committed a crime that would put him in the court of assize, then the prosecutor can, by offering to divert the case down to the correctional court by reclassifying the offense or charging differently, as it were, from a crime to a délit, then the defendant is subject to a lesser jeopardy. And if prosecutors offer to do this and defendants agree so as to limit the jeopardy for their crimes, it looks a great deal like plea bargaining without a lot of the explicit negotiation that makes American-style plea bargaining so ugly. And so, this is a way to achieve the cost savings that plea bargains bring to adversarial systems in inquisitorial systems that can't adopt explicit plea bargaining, and because the line separating crime from délit is determined by the legislature, it can easily be moved up or down to accommodate changing offense rates. So if, for example, in Paris or Marseille, the crime rate has increased substantially, so that if every defendant were given a full-scale trial in the court of assize, then in fact the court would be threatened with collapse because there aren't enough resources, then the legislature can facilitate easing the crisis simply by moving the line separating more serious from less serious crimes up the scale, so that what were heretofore more serious crimes are turned into delit and therefore subject to lower sentences, so a larger proportion of the caseload can be diverted toward those alternative methods, the less costly method of the correctional court. It's an effective response, and it works without explicit plea bargaining, but it does do a great deal of violence to compulsory prosecution. After all, when the prosecutors make that crucial move of redirecting a case from the court of assize to the correctional court, they must reduce the charge that brings the case into the correctional court. And when they do that, defendants are convicted, if they're convicted at all, in the correctional court of an offense which is not as serious as the one which the prosecutor originally seems to have believed they actually committed. Unless, alternatively, prosecutors are overcharging so that when the case is then bargained down into the correctional court, it actually is a clear and accurate representation of what the defendant actually did. Either way, the rule of compulsory prosecution is left pretty much in shreds at the end of the day. There's a similar system on display in Germany, and it's organized around what the Germans call Strafbefehl, which is a penal order. In Germany, there's a similar line separating more serious crimes, called Verbrechen, from lesser crimes called Vergehen. And for these lesser crimes, the Vergehen, offenders may, at the discretion of the prosecutor, be offered a penal order, which is much like a parking ticket, in that it specifies the charge that the defendant is being charged with, the crime that the defendant is being charged with, and it specifies a fine that the prosecutor specifies that the defendant can pay in order to resolve the charge that is indicated on the penal order. So, much like an American parking ticket, the ticket tells you what you did, it tells you what the fine is, and it invites you to mail the fine in with the parking ticket, and if you do so, you will have convicted yourself of the parking offense, and you will have paid the punishment that the prosecutor would have attempted to have a court impose upon you if you challenged the ticket and simply didn't send the money in as you did. So, just like a parking ticket, in Germany, the accused can simply send the penal order back to the prosecutor, sign a line that acknowledges guilt, and I guess that amounts to a guilty plea, and then return the penal order with the amount of the fine to the prosecutor. And when it's received, the case is then resolved just the way an American parking ticket is resolved, all of it without the need for any judicial proceeding at all, unless the accused, whose right it remains to do so, demands to have such a proceeding. There's evidence in recent years that prosecutors, just as they do in France perhaps, bargain over downgrading offenses so as to make them eligible for a penal order. And here, too, as in France, the legislature can cooperate with this by raising or lowering the line that distinguishes Vergehen from Verbrechen to bring more crimes, serious crimes, Vergehen into the Verbrechen into the Vergehen category, and thus, as it were, divert a larger proportion of cases, here again, to the non-trial procedure through the penal order and its parking ticket-like qualities. Again, Strafbefehl is a flexible, effective response to the caseload crisis. It achieves convictions without the overt plea bargaining, which Europeans continue to find so distasteful in the United States. But here, too, this flexibility and effectiveness come at the cost of compulsory prosecution in a very large fraction of the cases, insofar as crimes that are at the lower end of the scale are treated with penal orders, there is no investigation of the crime to speak of, and there's no official report that's certified by a judge. And of course, to the degree that German prosecutors are bargaining over reducing charges to make defendants eligible for a penal order, just as suggested in the case of France, this too may be done so that prosecutors can overcharge, produce the incentive for defendants to take the penal order, which then can be made to represent more closely what defendants actually did. But this too comes at the cost of the rule of compulsory prosecution. For a while in the 1970s and 80s, there was an academic debate over whether or not the European procedures could or could not be called European plea bargains. And much of the debate was fueled by the distaste with which large numbers of people, both in Europe and the United States, view the American practice of plea bargaining. It's not a very pretty spectacle, and so for an American law professor, as Professor Abraham Goldstein of the Yale Law School did in the 70s, to say to the Europeans that the sorts of procedures that I've just described amount to European plea bargaining was enough to raise the hackles of their European colleagues and to join the debate, a rather picky debate over whether or not one procedure did or did not correspond to the American practice of plea bargaining. What's more interesting is not whether or not a Strafbefehl is exactly like a plea bargain. Obviously it isn't, nor is the system of diversion in the French case. What is important is that the inquisitorial systems are facing exactly the same sorts of problems, the caseload pressures and the limited resources that have caused the American and English systems to turn so decisively in the American case to plea bargaining, and in a situation where plea bargains, American style, are not available, the European systems are doing the best they can to accommodate the increasing number of cases that they're seeing with the limited judicial resources that they have. And so, replacing the rather sterile debate about whether Strafbefehl or the correctional courts represent plea bargaining or not, more recent scholarship has tended to emphasize not the differences between the two systems of criminal procedure, but their similarities, with the argument that as different systems face similar pressures, with their responses constrained by the differing commitments of the two systems, that these differences are not easily sustained in the modern world given the rising caseload pressures. And some observers are beginning to argue that in confronting the common problems, the two kinds of systems, adversarial and inquisitorial, may be slowly converging. An interesting proposition, since as I've described the two, it would appear that there isn't much room for convergence with systems that take such divergent approaches to what the purpose of a criminal trial is. On the other hand, some evidence in favor of a thesis of conversion comes from Italy and from Germany since the year 2000, where legislation has been put in place to permit explicit sentence bargaining by defendants in both of those systems of criminal justice. I'm out of time, and so our course has come to an end. But before I ride off into the sunset, I'd like to thank some people who have made it possible for me to have such a good time offering these lectures to you. So my sincere thanks to all of the many very good people, both here at Wesleyan and at Coursera, who have worked so hard to bring this course to you. And special thanks to my friends Kevin Williarty, Lily Kaplan, and Shurya Sen for doing a great deal of the legwork that was necessary to put these lectures together. Most of all, I'd like to thank you for allowing me to do this and for joining me on this journey through the introduction to law and economics. I do hope you've enjoyed the course. I do hope you'll value what you've learned from it, and I do hope you'll continue thinking about the issues that it raises. Cheers.